I was reading the marriage section of the New York Times this past weekend, and I saw a piece about the wedding of a couple in Manhattan earlier this month, Peter Pringle and Sonia Jacobs. Their photograph wasn't that unusual. Perhaps they were older than most newlyweds. Sonny was 64, Peter 73. But it was the story of their lives and their coming together that we will spend the rest of our show on today. Both Sonny and Peter have survived the death penalty. They survived death row and have been exonerated since.
Sonia Jacobs and Peter Pringle each served a decade and a half on death row. Jacobs here in the United States, Pringle in Ireland. Both gained freedom after their convictions were overturned for murders that they steadfastly maintained they did not commit. The two would both become passionate anti-death penalty activists, and their activism brought them together.
Peter Pringle was accused of participating in a murder of 2 police officers following a bank robbery in Ireland. After his conviction, he was sentenced to death by hanging. Just days before a noose was to be tied around his neck, Peter learned that Ireland's president had commuted his sentence to 40 years without parole. He then immersed himself in legal texts and effectively became a jailhouse lawyer. Serving as his own counsel, he eventually convinced the Court of Criminal Appeal to quash his conviction.
Sonia, known as Sonny, was sentenced to death along with her then-husband at the age of 28 for the alleged murder of 2 police officers in Florida. Her 2 young children were cast into the foster care system. Although the 2 maintained their innocence, it was after her husband was executed and another man confessed to the murder that she was exonerated. Nearly 17 years after her arrest, Sonny's conviction was overturned on appeal.
For some, a wrongful conviction is not the end of the story. It is the beginning of a lifelong mission to heal. Sonny Jacobs and Peter Pringle, both wrongly convicted and later exonerated, chose to dedicate their lives to helping others find peace after trauma. Their retreat centers in Ireland and Florida are sanctuaries of healing, proving that survival is possible. But not all who suffer injustice are so fortunate.
It's February 2017. A 51-year-old woman, Annette Hewins, is rushed to a South Wales hospital. Once inside, she bangs on the windows, jumps on a table, and screams out something about a baby being taken away. Then she cries out to the medical staff, "Find the real killers." A relative tells nurses that Annette was a victim of a miscarriage of justice. Annette was free from prison, but not its effects, like having become hooked on heroin, leading her to have hallucinations and acts of paranoia. A psychiatrist is summoned to the hospital, but as the time goes by, the family becomes increasingly concerned. Within 24 hours, Annette would be dead.
Annette Hewins was wrongly convicted of arson with intent to endanger life. A mother of 3, she was 3 months pregnant with her 4th child when arrested. While in custody, awaiting trial, she gave birth, only to be separated from her newborn within hours. The trauma of imprisonment took a heavy toll on her mental health, leading her to heroin as a means of coping, an addiction that followed her long after release. 18 years later, at just 51, she was detained under the Mental Health Act and admitted to a hospital where she passed away the next day, her body overwhelmed by the lasting effects of wrongful conviction and addiction.
Where's Josh? Sir, we've done it.
Do you want to write it or do you want me to write it for you?
You write it. I'm all upset. I didn't do it!
The person responsible for the murder was probably a person with a car. And secondly, he was a person with a sexual problem. In view of all the evidence, it is clear, isn't it, that on the day that the murder took place, the accused was a person with a sexual problem.
Come on, step aside, lads. Come on, if you're coming down.
And the result is that it has been shown that this man cannot produce sperm. This man, therefore, cannot have been the person responsible for ejaculating over the little girl's knickers and skirt, and consequently cannot have been the murderer. For those reasons, this appeal must be allowed, and the conviction quashed as being unsafe and unsatisfactory.
Stefan Kiszko, who at the mental age of a 7-year-old was wrongly convicted of the rape and murder of Leslie Mulseed, an 11-year-old girl. The isolation and horror of wrongful imprisonment led him into a spiral of severe mental illness. Even after his name was cleared, he never truly escaped the shadows of his wrongful conviction. A heart attack claimed his life just 1 year after release. A wrongful conviction is not just a legal mistake. It is a life sentence of suffering, a torment that often shortens lives. Some, like Sonny Jacobs and Peter Pringle, have managed to rebuild and find purpose, but for too many others, the consequences are often profound and enduring, affecting nearly every aspect of their life. A wrongful conviction is a profound miscarriage of justice, but what makes its damage even greater is that it is inflicted by the very institutions designed to uphold justice and protect citizens. When an individual is wrongfully convicted, they suffer not just for the loss of freedom, reputation, and opportunities, but also from a deep betrayal by the legal system they were taught to trust. This betrayal intensifies the psychological and emotional toll. People generally expect harm from criminals, but when the police, prosecutors, and courts, institutions meant to ensure fairness, become the source of injustice, the sense of violation is far deeper. It creates a unique kind of trauma, as the wrongfully convicted person realizes that the very safeguards meant to protect their rights have instead been weaponized against them. When the state, with all its power and authority, wrongly convicts an innocent person, it does more than just take away their freedom. It strips them of their reputation, opportunities, and years of their life. Given this grave injustice, the question must be asked: what responsibility does the state have in repairing the damage? Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In today's video, we will examine what compensation and other forms of redress, if any, are available to those who have suffered a wrongful conviction. We will take a close look at the Law Commission's proposal for reform, exploring whether they go far enough in delivering justice to the wrongfully convicted. Are these measures truly fair and adequate, or do they fall short of what is needed? Join us as we break down the legal, financial and social consequences of wrongful convictions and discuss what meaningful change should look like. But before we proceed, a quick reminder to support our mission to humanize the criminal justice system by subscribing to our channel and liking and sharing our content. Thank you. We have discussed the current compensation scheme in great detail in this video. We gave a detailed overview of the current compensation scheme. We recommend you watch this video if you haven't already for background information. In summary, as the Law Commission explained, the current compensation scheme is based on the International Covenant on Civil and Political Rights, ICCPR. Since its ratification in the UK in 1976, the ICCPR imposes on the UK an obligation to provide compensation in specific circumstances. The Law Commission provides a detailed analysis of how the system operated in the past, how it functions today, and the changes that led to the current framework. Among these changes were the removal of ex gratia payment in 2006, the introduction in 2014 of a restrictive definition of miscarriage of justice, which now requires exonerees to prove beyond reasonable doubt that they did not commit the offence, and the imposition in 2008 of a cap on the amount of compensation that may be payable. The maximum amount of compensation for someone who has been detained for at least 10 years is £1 million, and the maximum in any other case is £500,000. We will not explore these details here, but they can be found at pages 531 to 543 of the Law Commission consultation paper. Since the abolition of the ex gratia scheme, compensation claims must be made under Section 133 of the Criminal Justice Act 1988. The Law Commission states plainly the threshold for compensation is now very high. In summary, a claimant must have been convicted, not simply held on remand, in order to be eligible. Also, their conviction must have been quashed through an out-of-time appeal or a CCRC reference on the basis of a new or newly discovered fact. Furthermore, the new or newly discovered fact must show beyond reasonable doubt not that the conviction was unsafe, which is the test applied in the Court of Appeal, but that the individual was innocent beyond reasonable doubt. The claim for compensation must be brought within 2 years of the conviction being quashed. These exclude a number of claimants, including those who brought an appeal within time, who had their conviction quashed where there was an error in the trial, or evidence has subsequently been lost or destroyed, and they are therefore unable to prove their innocence. Such claimants will be unable to satisfy the requirements irrespective of their true innocence. It would also exclude someone whose convictions was quashed on the basis of fresh evidence, which did not prove beyond reasonable doubt that they had not committed the offence, but where subsequent evidence did demonstrate this. For instance, where another person was later convicted at trial of having done so. To give a plain example of the unfairness of this compensation scheme, the Law Commission refers to the Post Office Horizon scandal. It says that despite the Horizon scandal being described as one of the greatest miscarriages of justice, it is likely that the vast majority, if not all, of these victims will be unable to meet the high standard required under Section 133 to prove their innocence beyond reasonable doubt. This is due to the lapse of time and the nature of the operation of the Horizon computer system, including its numerous defects. In addition, this individual would not receive £600,000 as they have been awarded under the ordinary compensation scheme, given that the amount payable is capped, as we said, at £500,000 for sentences of imprisonment that are less than 10 years. Those who were jailed as a result of the Horizon prosecution, a minority of those convicted, received much shorter sentences than these. The rationale behind this strict system is the belief that not guilty persons should receive compensation. The Law Commission explains, in Chapter 4, we concluded that the primary goal of the criminal justice system is to acquit the innocent and convict the guilty, with acquitting the innocent taking precedence. However, the current compensation scheme appears to prioritize preventing the guilty from receiving compensation over ensuring that the innocent are compensated. While we agree the compensation for exonerees should be reserved for those who are actually innocent, we have consistently emphasized that proving innocence, whether on the balance of probability or beyond reasonable doubt, is in some cases an insurmountable challenge, requiring an individual whose unsafe conviction has already been overturned to further prove that they did not commit the offense, especially to the extraordinary high standard of beyond reasonable doubt, is not only unreasonable but fundamentally unjust. Once the state has exercised its authority to wrongfully deprive an individual of their liberty, it has an ethical duty, independent of any legal obligation, to repair the harm inflicted. The consequences of wrongful imprisonment extend far beyond the loss of physical freedom, often including psychological trauma, reputational damage, financial ruin, and profound disruptions to personal and professional relationships. Denying compensation unless exonerees can meet an excessively burdensome standard of proof only serves to compound their suffering and prolong the injustice they have endured. The Law Commission agrees, but in our view it does not go as far as it could go, and concludes as follows. We provisionally propose that the requirement that the applicant for compensation must show beyond reasonable doubt that they did not commit the offence amounts to an unjustified and often insurmountable legal burden which conflicts with fundamental principles of civil and criminal law. We provisionally believe that lowering the standard of proof to the lower standard of the balance of probabilities is the best way to ensure that victims of miscarriages of justice can access compensation for their wrongful conviction and imprisonment. A person who can show on the balance of probabilities that they were innocent should be entitled to compensation. Additionally, we acknowledge that as with concerns as to the separation of powers with the Home Secretary's previous power to refer cases to the Court of Appeal, issues may be seen to arise with the Secretary of State deciding on issues of relative innocence and guilt. We provisionally conclude that it should not be for the Court of Appeal to decide compensation because it is not regularly familiar with the considerations associated with making compensation awards and their amount. However, we are interested in hearing views about whether a body independent from the Secretary of State, perhaps analogous to the CCRC, should be the entity to decide whether a person whose conviction was quashed was factually innocent on the balance of probabilities. We firmly believe that the Law Commission's proposal lacks the boldness needed. As Baroness Kennedy rightly observed, requiring individuals to prove their innocence beyond reasonable doubt is an affront to our legal system. It contradicts a fundamental legal principle that recognizes the difficulty of proving innocence. We go even further. This is exactly why our trials are focused on determining guilt or not guilt rather than proving innocence. And for this reason, we strongly believe the compensation should be automatically granted when a conviction is overturned, unless there are clear and specific grounds for denial, such as an admission of guilt or a procedural error where guilt can still be inferred. Compensation should not be subject to an additional adversarial process, but should be granted at the same time as the exoneration itself by the Court of Appeal. Such an approach not only ensures fairness, but also reaffirms the state's commitment to justice, accountability, and the protection of individual rights. The Court of Appeal should then refer the case to an independent assessor to decide the amount. Needless to say that we also advocate for the removal of all other restrictions, including the 2-year time limit, the newly discovered fact, and the requirement that the appeal must be out of time. But as we said, there shouldn't just be compensation. The state must go further to assist the wrongfully convicted with other support. The state has a moral and legal responsibility to respond comprehensively to wrongful convictions, both to repair the harm done to individuals and to prevent future injustices. We are delighted that the Law Commission agrees with this point. Currently, great focus has been placed on the rehabilitation and reintegration of prisoners. We are talking about those rightly convicted, which we agree with. Leaving prison is a huge transition, and thankfully there are some systems in place to help people get back to their feet, which include support before release, for example, whereby in the last 12 weeks of their sentence, prisoners get some help preparing for life outside. This includes advice on finding somewhere to live, managing money, getting a job. Extra support is also available for those who have struggled with substance abuse, experienced domestic violence, or engaged in sex work. Prisoners may also be allowed out on resettlement day release to do things that will help with their transition, such as attending a work placement or training course, going to school or college, reconnecting with family. Some may even get resettlement overnight release, allowing them to spend the night at the home they will be living in after release. In 2021, the government introduced more measures to support people leaving prison. The idea was to give them a fair shot at reintegration and reduce the chances of reoffending. These included allowing prisoners to start work before their release through temporary leave, providing community treatment for drug and alcohol addiction, ensuring every prison leaver is registered with a GP for better mental health support, expanding access to community mental health services. There is also a plan to roll out a new support service by 2025 for high-risk offenders with complex needs, ensuring they get the right treatment and guidance. One major issue many face after release is lacking the basics like ID, a bank account, or even a CV. To fix this, the government promised ensuring every prison leaver has an ID proving their right to work, expanding the prisoner banking program so everyone has a bank account ready, helping with writing CVs and setting up job interviews, making sure prison leavers have job centres and probation appointments lined up. The new government, as of September 2024, has reinforced its commitment to reducing reoffending and improving education and job opportunities for prisoners. In early 2025, the Lord Chancellor Shabana Mahmood announced further reforms aimed at strengthening probation services and better supervising released offenders. All of this is meant to break the cycle of reoffending and help people rebuild their lives after prison. These steps are crucial in making sure prison leavers have a real chance at a fresh start. While these reforms are a step toward a more humane criminal justice system, which we support, they don't benefit everyone, especially those who maintain their innocence. According to the Law Commission and groups like Progressing Prisoners Maintaining Innocence, people who refuse to admit guilt often face major hurdle in prison. Since progression through the prison system is tied to accepting responsibility, innocent prisoners struggle to move to lower security prisons. This means they often serve their sentence in high category facilities, making their transition back to society even more jarring. Risk staying in prison longer without completing rehabilitation programs, which often require admitting guilt. They may be denied early release. Face added emotional and psychological strain. The constant pressure to confess, combined with a lack of progress, can deepen feelings of injustice and make the experience even more devastating. We have discussed these issues in this video, which is linked below. Be sure to check it out if you haven't already. For many victims of wrongful convictions, release from prison isn't just freedom, it's another battle. The system still has a long way to go in recognizing and addressing these challenges. Currently, there is only one organization which provides dedicated support to an individual wrongly convicted in England and Wales. That is the Miscarriage of Justice Support Service, MJSS. But what are the issues with this service? The Law Commission reveals that the purpose of the MJSS, according to tender documents, is to provide advice and support in relation to practical issues such as housing, social security benefits, and health care. The documents do not mention resettlement or reintegration. The MJSS remit includes finding accommodation, establishing income and training, applying for national insurance credits, registering with a general practitioner, and assessing any healthcare or counselling needs. The MJSS also assists with opening bank accounts, budgeting, finding a solicitor where compensation is sought, and providing more general support with family or relationship issues. However, as seen in cases like Annette Hewins, who endured these hardships alone for 18 years until her tragic, untimely passing, the impact of wrongful convictions extends far beyond the immediate challenge of release. The psychological toll of being wrongfully imprisoned is profound and unique, compounding over time and leaving lasting emotional scars that go beyond practical difficulties. Indeed, we analyzed this with the help of Professor Greenberg in this video, and his research is acknowledged by the Law Commission consultation paper. The Law Commission refers also to studies which found that the MJSS is operating under a limited remit, and despite its best efforts, there remains a gap in the system to assist with the reintegration of those wrongly convicted. This includes a lack of specialized psychiatric and emotional support to address the challenges faced by the wrongly convicted. One of the consultees, Justice, a cross-party law reform charity, concluded that whilst the MJSS provides some of the assistance that is required, it is not able to meet this group needs. The MJSS is very successful at securing social security benefits and accommodation, but it finds it difficult to find appropriate mental health services that such individuals require. Moreover, the remit of the MJSS is further limited by the fact that funding is provided through a renewable yearly contract. This means the long-term planning is difficult for the organization. The Law Commission rightly highlighted the paradox that a wrongly convicted person, unjustly deprived of their liberty, receives less support than someone who has actually committed an offense. So what can be done? How can we fix this imbalance and ensure the victims of wrongful convictions get the support they need? Some have suggested that dedicated healing retreat centers, like those established by Sunny Jacobs and Peter Pringle, should be created to support those who have suffered wrongful convictions. On a somber note, it is also important to acknowledge that Peter Pringle sadly passed away in January 2023. His legacy, however, continues to inspire efforts to help exonerees heal from the profound trauma of wrongful imprisonment. Several other suggestions were provided by various consultees, such as an immediate interim package that includes financial support, a mechanism to have criminal convictions immediately removed from the police national computer. The Law Commission saw merit in a support package including greater access to housing, greater transitional care, as well as long-term social services, including mental health support. However, we would welcome consultees' views, said the Law Commission, on whether other support measures may be necessary. And at question 102, they ask, we provisionally propose that victims of miscarriages of justice should be entitled to support in addition to financial compensation. Do consultees agree? They also welcome consultees' view on what other support measures may be necessary. Our view is the state has a moral and legal responsibility to respond comprehensively to wrongful convictions, both to repair the harm done to individuals and to prevent future injustices. A proper response should include immediate exoneration and support. Once new evidence proves someone wrongfully convicted, the state must act swiftly to exonerate them rather than delaying justice through bureaucratic obstacles. Exoneration should come with official acknowledgement of wrongdoing to clear the person's name. Immediate release without unnecessary legal delays, and access to emergency housing, healthcare and financial assistance to help them transition back into society. In addition, there should be swift financial compensation and restitution. A wrongfully convicted person has lost years, sometimes decades of their life. The state should compensate them fairly, considering lost wages, emotional suffering, and the life opportunities stolen from them. The compensation should be based on the true impact of wrongful imprisonment rather than being limited by an arbitrary cap. The compensation process should be automatic upon exoneration rather than requiring victims to go through another legal battle. Wrongful incarceration causes deep psychological trauma. The state should provide psychological and social support. Free mental health counseling and therapy to help individuals cope with PTSD, depression, and anxiety. Job training and education programs to help them regain independence and reintegrate into the workforce. Social services, including assistance with housing and medical care, to address the struggles of returning to normal life. The state must ensure accountability for systemic failures by investigating what led to the wrongful conviction and hold accountable those responsible, whether it was misconduct by police, prosecutors, or experts. Steps should include independent review of wrongful convictions to identify patterns of errors, such as unreliable forensic methods, false confessions, or prosecutorial misconduct. Disciplinary actions against officials who engaged in misconduct, such as fabricating evidence or withholding exculpatory information. Reforming police and prosecutorial practices to prevent future injustices. The state must take proactive measures to identify the root causes of wrongful conviction and implement legal reforms to prevent them, including stricter standards for the admissibility of expert evidence. The government must openly acknowledge wrongful convictions and commit to transparency in an effort to restoring public trust. This includes public education on wrongful convictions to ensure people understand the flaws in the justice system, stronger legal protections for defendants, including better access to legal aid, legislation ensuring automatic compensation and post-exoneration support rather than requiring victims to fight for justice again. A wrongful conviction is one of the gravest injustices a person can suffer. This state must not only correct these injustices when they occur, but also work aggressively to prevent them. True justice demands accountability, support, and a commitment to ensuring that no innocent person suffers at the hands of the very system designed to protect them. I hope this video has been insightful and inspiring. If you share our mission to humanize the criminal justice system, please support us by subscribing to our channel. Join us again as we sit and rise in this unique trial.